Hello everyone, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thank you for joining us. This is perhaps one of the questions we get here at Washington Gun Law, and so in our little ongoing series of short videos trying to quickly summarize some of Washington's complex self-defense laws, I thought we'd spend a few minutes today and talk about when can I use deadly force in Washington State. Okay, before we get rolling, if you guys like this video, go ahead and click that like button down below if you want to stay up to date on issues related to your Second Amendment rights, not only on a statewide level, but a nationwide level. Go ahead and click the subscribe button down below. If you click the little bell logo down below, of course, you'll be notified when we post new videos. And most importantly, I really want to see the comments come through in the comment section. That's how the YouTube algorithm ends up distributing our video to more lawful and responsible gun owners like yourself. And that's what we're trying to do here, is build a huge online community where we can all share ideas and thoughts about protecting our Second Amendment rights. Okay, so in following up with our first part in this short video series about the general laws of self-defense, is a refresher. We know that when we are using force to defend ourselves, we want to summarize it basically in 3 words. That force must be necessary. That is, we have no other means or alternatives by which we can save ourselves. So the force is necessary. The force is reasonable. That is, our perceived need to use the force, both from an objective and subjective standpoint, is reasonable. That is, a reasonably prudent person would have thought the same thing. And then finally, that the amount of force we use must be proportional to the force that we are trying to repel. So that brings us to, when does an individual in Washington State get to use deadly force? RCW 9A.16.010 subsection 2 defines deadly force as: deadly force means the intentional application of force through the use of firearms or any other means reasonably likely to cause death or serious physical injury. So, obviously, the most common way in which deadly force can be inflicted upon another is through the use of a firearm, but certainly there are many other weapons. Even common everyday items not designed to be weapons can in fact be deemed deadly weapons for the use of deadly force. Baseball bats, clubs, automobiles, kitchen knives, which are not normally designed to attack people, but any of those household items can also be deemed deadly weapons. Now, amongst the litany of statutes that we talk about here at Washington Gun Law, RCW 9A.16.050, which is in the defense section of the General Criminal Code, actually codifies when homicide is justifiable. That statute reads as follows: homicide is also justifiable when committed either 1. In the lawful defense of the slayer, or his or her husband, wife, parent, child, brother, or sister, or of any other person in his or her presence or company, when there is a reasonable ground to apprehend the design on the part of the person slain to commit a felony or to do some great personal injury to the slayer or to any such person, and there is imminent danger of such design being accomplished. And again, a very wordy way of saying homicide is justifiable. That is, you can use deadly force if there is an attempted felony being committed upon you, any member of your family, or any person in your presence, and there is a reasonable belief that that felony may be carried out. Subsection 2 of RCW 9A.16.050 also describes another situation in which homicide is legally justifiable. Homicide is also justifiable when committed either 2. In the actual resistance of an attempt to commit a felony upon the slayer in his or her presence, or upon or in a dwelling or other place of abode in which he or she is. So, by statute, we can use deadly force whenever a felony is being committed upon us, upon somebody in our presence, a family member, any act which could cause death or serious bodily injury to another person, and there is a reasonable belief that that threat could be carried out. In any of those situations, including if a felony is being committed in your dwelling, your place of abode, a place where you are lawfully allowed to be, if a felony is being committed against you, yes, you have the right to use deadly force. Now, while we can sit there and analyze statute, we know from our videos here at Washington Gun Law that case law really defines what the law means. And there's a case out there, State v. Walden, that I think best sums up when you can actually use deadly force. It reads as follows. Deadly force may only be used in self-defense if the defendant reasonably believes he or she is threatened with death or great personal injury. And I really think that that case law very clearly sums this up. So if we go back and we take a look at general rules of self-defense, it must be necessary, it must be reasonable, and it must be proportional. And so if we get to that last element, proportional, the only time that using deadly force to defend yourself would be proportional is when you are repelling a perceived threat of deadly force. So if you are in imminent threat of death or serious bodily injury, if somebody else in your presence is in imminent threat of death or serious bodily injury, then Washington law says that deadly force may be used. Now listen, it's one thing to be able to tell you what you have the right to do, but as we talk about all the time here at Washington Gun Law, sometimes there is a difference between what you have the right to do and what you should do. And I caution anybody before employing deadly force to consider the impact that it will have on you in many ways that you right now would probably not even imagine. I have had many clients who have lawfully pulled the trigger. They were absolutely justified in pulling that trigger. But the fallout that they suffered was immeasurable. They suffered professionally, personally, emotionally, every way humanly imaginable, even though the shooting was in fact justified. So as I mentioned, part of being a lawful and responsible gun owner is going out there and training yourself, not only in the law, but in the tactical situations that you need to understand that you may likely find yourself in. That's not our area of expertise there, but there are a lot of fantastic NRA instructors out there that can help you. But please always remember that while you may have the right to do something, choosing to do the correct thing sometimes means going beyond what you just have the right to do. So, in summary, a person may use deadly force in self-defense only if they are in imminent threat of death or serious bodily injury, if a felony is being committed against them, a family member, or somebody else in their presence, or if a felony is being committed inside their abode or dwelling or other lawful place that they are inside. Absent any of those circumstances, the use of deadly force in all likelihood will be deemed excessive, and yes, you will be facing criminal liability. Listen, you may have more questions about the use of deadly force or anything related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Listen, part of being a lawful and responsible gun owner, like we talk about here all the time at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.